Welcome everyone to part 6 of the Path to a Patent series. As Ronaldo said, my name is Karen Weiler, and I am a special program examiner in the International Patents Legal Administration. So I was for many years a patent examiner, and then I took on this new position in our international group. And it's in that role that I get to teach the public and internal as well about the Patent Cooperation Treaty and a little bit about the Hague system, which is what we're going to talk about today. Okay, so as you enter your questions into the Q&A, Ray and Dan will be trying to help you there. However, if there are questions that are left over at the end, I can try to address them then. Okay, so as I said, we're going to focus on pursuing patent protection abroad and focus on two international treaties called the Patent Cooperation Treaty and the Hague System for Industrial Designs. All right. Okay. So to begin, we're just going to start with some general patent info. It'll be kind of a review refresher for those of you who have been coming to this series, although I think we'll probably touch on some things that are new. So basically, a patent is an exclusive property right granted for an invention. And so while patent rights vary by country, typically a patent gives its owner the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. Okay. The term or duration is limited. For most countries, including the US, it's 20 years from the filing of the patent application. And key is that it is a territorial right. So one only has patent protection in the country where, or countries where patent was granted. So a patent that was filed and granted in the US would only give the patent owner protection in the US, not anywhere else. So in exchange for this property right, the inventor must disclose the invention, and doing so gives information to the public that promotes progress in that technology. So who grants patents? That would be the job of national patent offices, such as the USPTO, the Japan Patent Office, Korean Intellectual Property Office, and so forth, and regional patent offices, of which there are 5 that are listed right here, and in more detail on this slide. So this shows the members of the 5 regional patent offices. Okay, each of the countries and their country codes. In this case, this is the membership of the European Patent Office, or EPO. They have extension or validation agreements with certain non-member countries, which are shown here. And essentially how that works is that if applicant submits a request for extension or validation in a timely fashion and pays the extra extension validation fees, then the property rights would have effect in those countries. Okay. So if we just focus on US patents, there are 3 types. Okay, so that's the case for the US, and you probably are familiar with these. There would be the utility patent that protects the functional aspects of an invention. These patents are directed to a new process, new machine, article of manufacture, composition of matter, or any useful improvement thereof. One example that we often offer here is a mobile phone and all of the technology that's packed into that phone. Many, many patents could be there. So the utility patent has a 20-year term from its filing date. The design patent, in contrast, protects the ornamental aspects of an article, such as its design or shape. So these patents are directed to new, original, and ornamental designs, for an article of manufacture. So the invention here is the way that the article looks rather than how it functions. Continuing with the mobile phone example, the particular shape of the phone or how the control buttons are configured on the phone could be covered by a design patent. And the term for a design patent is 15 years from the grant date. And finally, there is a plant patent, and that is directed to a distinct new asexually reproducing plant, which essentially means that the plant is not reproduced using seeds. And so having a plant patent prevents others from growing and selling the plant. It has, like the utility patent, it has a 20-year term from the filing date. And on this and the next couple of slides, we just have examples of the front page of a patent. So here are two utility patents. On the left is a patent for a tremolo device for stringed instruments issued to Mr. Fender in 1956. And on the right, a little more recent patent for a water purification system. And that was issued to a student inventor, Ms. Kurup, in 2020. And here are two examples of a design patent. On the left is a design patent for the Gibson Flying V guitar, issued in 1957. And on the right is a design patent for Crocs footwear, issued in 2015. And finally, two examples for a plant patent. So on the left is a sample plant patent from 2014 for a new cultivar of curcuma. And on the right is a plant patent for the Honeycrisp apple tree, issued in 1990. Okay. So now let's move on to the big question of where to try to get a patent. Okay, so that is a significant question because, as mentioned on the first slide, patent rights are territorial. So protection against infringing activities is only within the country or region in which the patent was granted. Since there is no worldwide patent, one must apply for and be granted a patent in each country or region of interest where protection is desired. And given the worldwide economy, patent protection can be an important part of the overall business strategy. So we'll then discuss some considerations then in trying to answer this question of where to patent. And a chief one would be business considerations. So the current and potential market size of a country or region is an important factor to consider because if the market's too small, then the product may not be commercially viable there. How much it will cost to manufacture the product and where the product can be made should be determined. One should learn about economic trends, the industry size, and future growth of a particular region or country. It also is important to investigate what your competitors are doing in making this decision. And finally, determine the cost of filing and prosecution of a patent application in each country or region of interest. There are also patent law considerations because the standard of patentability and the types of protection granted can differ in each country or region. Okay. So regarding the standard of patentability, there can be patentable subject matter differences. Okay, there are. So for example, there can the type of technology of a method for treating a human or animal body is something you can patent in the US, but you cannot get a patent for that in the European Patent Office. Okay. I mentioned that there are three types of patents in the US, the utility, design, and plant. Most countries do not grant a plant patent. There are other types of protection for plants, but okay. So there can also be, there are prior art differences. So recall that prior art is evidence that an invention is already known. What one country considers prior art can be slightly different from what another country considers as prior art. Okay, so looking into that is important. Furthermore, there are some countries that do not do substantive examination. Instead, theirs is just a registration system. So regarding the types of protection granted, right, the US grants patents, those 3 types we talked about. I've mentioned national patents and regional patents, but there's also inventor's certificates, utility models, patent of addition, certificate of addition, petty patent, industrial design, and that's just a few of them, right? So there can be many options in each country. So you may say, I want patent protection or I want intellectual property protection in country X. Well, you may have a choice of different types of intellectual property protection. So another patent law consideration is the grace period, which is defined as the time prior to filing a patent application during which public disclosure by the inventor or applicant is not to be taken into account in determining patentability. So if you're familiar with the US practice, you know that we have a grace period for the disclosure. It happens to be 12 months, but not every country region has a grace period, and the time, maybe if they have one, maybe 6 or 12 months. And the scope of the qualifying disclosure can be different. Okay? So it's not universal in the sense you can't just assume that 6 months before you file your application, if you're the inventor, you can talk about your invention and be fine with it. There are, let me say that the details of the grace period can be found in a document that is produced by the World Intellectual Property Organization, or WIPO. And I was curious, so I looked at this document. And so I found, for example, that there was one country where they had a grace period, but it was only for disclosure of an invention at a particular technical conference. Okay, so it wasn't only just the time, it was the where and how, right? So disclosure anywhere else could count against the inventor, okay, as prior art. Okay, so it's important to be aware of that. And in general, we advise just don't talk about your invention until you file that first application. So, and finally, enforcement considerations are important when deciding where to patent. So, enforcement of a patent requires action by the patent owner as well as by the courts. Okay, so one needs to develop an enforcement strategy for each country, since some countries may have weak or non-existent enforcement laws. Others may have acceptable laws, but the enforcement process may be slower and effective. So it's always a good idea to monitor your competitors to see if your patent is being infringed upon. Okay. And another consideration might be whether you might want to have a licensing agreement. So negotiate that with another company to sell or manufacture a product. So now we're going to move on to foreign filing routes. So how to foreign file a patent application. And so we're going to break it down into kind of 2 pathways, 2 routes. The first route that we'll explain in detail in the next couple of slides, we're going to call the direct route. And that is filing your patent application directly in each country or region of interest. That's provided for by the treaty called the Paris Convention. Then we're going to focus the rest of our discussion on filing an international application. If it's a utility application, then it'll be filed under the Patent Cooperation Treaty. If it's a design application, it'll be filed under the Hague Agreement. Okay, so we'll spend a fair amount of time talking about that. In either case, whether the direct option is selected or an international application is selected, a foreign filing license is frequently required. I think we pretty much covered this slide with the Paris Convention. So you have, for a utility application, 12 months after the filing of the first application to file a subsequent application claiming priority to that first application, which is basically claiming entitlement to the filing date of that first application. Okay. So for we'll call this a right of priority clock, starts from the date of filing of that first application. That first application can be a provisional application if we're talking about a utility application, or if we're talking about a design application, it must be a non-provisional application, or of course a utility. The priority claim can be made to one prior application, 2, 3, 4, multiple applications, but they all need to be filed within that priority period. So the 1 year for a utility application, the 6 months for a design application. So this timeline on the top here illustrates how direct filing abroad works, using an application for a utility patent as an example. So the filing of the first application in the home or local patent office starts that clock with the deadline of 12 months. And by 12 months, that's the deadline for filing an application for the same invention. Essentially, there can be differences, but essentially the same invention in one or more other foreign countries. Okay, in those foreign filed applications, and that's what this starburst here is. It's saying, okay, we're filing 2, 3, 4 different foreign applications. Each of those would claim priority to this first filed application under the Paris Convention. So during this 12-month period, the first application typically needs to be reformatted to meet the formal requirements of each other patent office in a different country. So every country has a different way that they like to see their patent applications. So we're talking about the order of different sections of the application, the margins, the font size, paper size even. So all those things may vary. So that needs to be done during this 12-month period. Hiring legal counsel in the different countries, possibly translating the application into a different language. All of that needs to be done. And then come the filing on or before 12 months. The national and regional fees will be due, and prosecution of the applications will start. Okay, so it's going to be a busy 12 months and then a busy time afterwards, managing the prosecution of all those applications. But certainly doable, especially if there's only a few applications. So that's what this slide points out. Why file directly in a foreign patent office? Well, it may be cost effective, especially if filing in only a few countries. If an applicant already knows what countries or regions where they want patent protection, that's another reason that this pathway, this direct route, is good. So within 12 months, you already have that decision made. If one is prepared to pay the filing costs, within a year, then this route works super well. And of course, it's necessary if a country is not a party to either of the two treaties, the Patent Cooperation Treaty or the Hague Agreement, for which an international application can be filed, which is what we're going to be talking about next. So now is our section beginning with the Patent Cooperation Treaty, which is the treaty for utility patent applications. So the Patent Cooperation Treaty, abbreviated PCT, is a United Nations treaty first signed in 1970, became operational 8 years later, in 78. So during those 8 years, the signatories of the treaty needed to adjust their international laws to their national laws, to accommodate the provisions of the treaty. The Patent Cooperation Treaty is administered by the International Bureau, or IB, of the World Intellectual Property Organization, WIPO, and they are located in Geneva, Switzerland. So I've mentioned that there is an international application, abbreviated IA, on many of our slides. So an international application is filed under the Patent Cooperation Treaty, but there is no such thing as an international patent, unfortunately. Okay, just national patents and regional patents, as was mentioned earlier. As we'll talk about, the PCT functions as a patent application filing system. The application must still be prosecuted in each national or regional office where patent protection is desired. So as described on the next few slides, the PCT simplifies the process of filing foreign patent applications. So when multiple patent applications need to be filed, this is often the right way to go. It also provides for a search of the prior art and a generation of a written opinion on patentability by a major patent office, which we'll discuss a little bit more later, which is of benefit both to applicants and also to other national and regional patent offices. An applicant also has the opportunity within the PCT to request a further examination of the application, again by a major patent office. So the PCT incorporates the provisions of the Paris Convention that we've just talked about, but it provides some advantages. So at the top of the slide here is a simplified PCT timeline. So under the PCT, similar to the direct filing strategy we first talked about, time zero is applicant filing that first application in the local or home patent office. There is still a deadline of 12 months, but in this case, the deadline is for filing an international application. And this international application would claim priority under the Paris Convention to this first filed application. This single application establishes a filing date in each signatory of the PCT. This application is advantageous in that it has a single set of formality requirements. So in other words, it's set forth in the treaty what the margins need to be, the order of the different sections, the font size, all of that sort of stuff. And all of the signatories of the PCT have agreed that they would accept an application that meets those formal requirements. This single application will undergo an international phase prosecution. So that would be this part of our timeline here, which we'll be talking about more. And the translations, potentially national and regional fees, prosecution, all that still happens, but it's delayed, okay, until this 30-month mark. Okay, so we still have this starburst here for entering national, for the application being prosecuted in different countries or nations, okay, but it's not until 30 months as opposed to the 12 months. So there is more than one way to foreign file using the PCT. So one can file a non-provisional application followed within 1 year by the PCT application. One can file a provisional application followed within 1 year by the PCT application. One could file a provisional application followed by both a non-provisional and a PCT, both meeting that 1 year deadline. Or there's no reason that there has to be a first non-provisional or provisional application. The first application could be the PCT application. So all of these, it just depends on what works best for the inventor, the applicant. So a country or region that is a signatory to the PCT is referred to as a PCT contracting state. There were only 18 contracting states when the PCT first went into effect. That number keeps on growing. It seems every year it is increasing. We are currently up to 158 contracting states, which will be listed on the next slide. But here is a link where you can find a listing of all of those countries. Okay, so as of April, that was the last time it changed. Here is all of the contracting states. And this is a world map which depicts each PCT contracting state in blue. And so it really emphasizes how most of the world's industrialized nations are signatories of the PCT. So a little history here. In 2024, the last full year that we have data for, there was an estimated 273,900 international applications filed worldwide. That was a slight increase from 2023. About 20% of these were from U.S. applicants. And so this graph here illustrates the trend in PCT filings for the top 5 contributing countries, including the U.S. We are in dark blue. We're not the leaders here. So right now we've got China, then this is Japan, Germany, and Republic of Korea are down here as the top 5 contributors to the filing PCTs. So this slide summarizes the benefits of the PCT application system for applicants. We've touched on these earlier. So it simplifies the process of filing foreign applications because there is just one set of formality requirements that are set forth in the PCT, and filing of the international application establishes a filing date that all of the contracting states of the PCT will accept. And they'll treat it as if it were filed in their country on that date. The process allows applicants to postpone the costs associated with filing in the national offices, so the costs for translations, the filing fees, legal counsel, and so forth, until at least 30 months from filing of that first application to which priority is claimed. It provides an early applicant with an early look at what might be the most relevant prior art related to their invention, as well as an opinion as to the novelty, inventive step, and industrial applicability of the claimed invention. And the next slide goes into this in a little bit more detail. But finally, the PCT provides applicants with extra time for assessment of commercial viability in the various designated states. So helping in making time to make those important decisions about where to pursue patent protection. Okay. So together, one might say the PCT provides applicants time and information necessary to make the appropriate business decisions. So the PCT is also of benefit to offices, meaning patent offices, national and regional. So the offices receive an international search report, or ISR, and a written opinion that is authored by an office called an International Searching Authority, or ISA. So the ISA is a large patent office that has been deemed to possess sufficient resources to conduct a comprehensive search of the prior art. So only a small subset of all of the patent offices have been granted this role as a potential international searching authority, or ISA. So optionally, offices as well as applicants might get a supplementary international search report from a supplementary international searching authority. The SISAs are a subset of the ISAs. And also optionally, an international preliminary report on patentability, Chapter 2, may be generated by an international preliminary examining authority, or IPEA. And again, that's a much smaller subset of all of the ISAs. So again, a large patent office deemed to have the resources necessary to conduct a comprehensive search. So returning now to the international application, or PCT application as we call it. So it is a single application filed by a resident or national of a PCT contracting state. It's filed in a single patent office that is referred to as the receiving office because it receives that application. And it's usually the applicant's home patent office, so the local patent office. It is filed in one language that is accepted by that receiving office. So for the USPTO, we only accept an application in English, but other countries may accept an application in a different language in more than one language. So we only offer the one. This international application must comply with the format prescribed by the PCT, but in doing so, it is going to be accepted by each national and regional office where patent protection is sought. So we've referred to them, these regional offices, where one might pursue patent protection as a designated state. And so sorry for all this terminology, but it comes with the territory here. And as mentioned before, this PCT application, this international application, is treated by each region or country as if it were a national application with a filing date of the international filing date, the date on which the international application is filed. So in the PCT filing timeline shown here, it incorporates a few more features of the PCT that we're going to discuss on the next few slides. At a high level, it illustrates that international phase of the PCT is the time period between filing of the PCT and entry into national phase, okay? Entry into national prosecution. Okay? So this period right here. So during this period, after filing, an international search is performed by the ISA. The international application is published. Applicant also has the option to request a supplementary international search or international preliminary examination. That goes backwards. Both of those are optional and additional cost. And then there's the deadline of 30 months from whenever the first application was filed. That's the deadline for choosing the countries or regions in which to pursue patent protection. So, and then national phase begins at this point. And so as indicated in that timeline, there are two phases of the PCT, the international phase and the national phase, which in the US we also call the national stage. The remainder of our discussion is going to focus on the international phase, although we'll briefly mention national phase, which starts at 30 months. So international phase So it starts off with the filing of the international application in a receiving office, usually the home patent office, the local office. 3 fees are due within 1 month of filing the international application. There is a transmittal fee that goes to the receiving office, and it covers the processing of the international application. There is a search fee that goes to the ISA for the preparation of the search report and written opinion. And there is an international filing fee that goes to the International Bureau of WIPO for the publication of the international application and for providing copies of the application to each of the designated states. So the search is performed by the International Searching Authority, or ISA. As mentioned before, the ISA is a large patent office that has good resources to conduct a comprehensive search of the prior art. Each receiving office enters into an agreement with one or more ISAs to serve as a searching authority for their applicants. At the USPTO, applicants here have 8 options, 8 different offices that can be an ISA, so they can choose. The ISA would issue the International Search Report, or ISR, or rarely, very rarely, in cases where the ISA finds that all of the claims are unsearchable, they might instead issue a declaration of non-establishment of the ISR. The search report lists all of the prior art that has been found that is relevant to the claimed invention. And then the ISA will also produce a written opinion, which is a preliminary and non-binding opinion on whether the invention appears to be patentable in light of the search report results. So next on our timeline is potential amendment and publication. So applicants may optionally amend only the claims, and PCT Article 19 provides for this option. Amended claims would be filed directly with the International Bureau because they are the ones that publish the application, and amending the claims is solely for the purpose of publication. So they don't get re-examined or researched or anything. Why might an applicant do this? Well, it might be thought to be beneficial if additional clarity is needed for the claims or to better define the scope of the invention. Right? So this will be made public. So it's giving notice to the public of what the invention is. The international application is published by the International Bureau at approximately 18 months. The International Search Report accompanies it, as well as Article 19 amendments to the claims if they happen to be any. These documents are published in the form of being made available on the IB's website, a particular page called Patent Scope. So that's a database of published PCT applications. Also has some other applications there too. This is an example of the first page of a published international application. This particular one was filed in Japanese, and we chose this because it illustrates the fact that no matter the language of filing, an English translation of the title and the abstract is always present. So even if the language, the application was filed in a language which one can't read, you can still look at the title and the abstract to get an idea of whether it's of interest, and then have a machine translation or other translation if it is of interest. So optionally, applicants can have a supplementary international search done by a supplementary international searching authority. That costs, and there is an extra fee associated with that. There is no supplementary written opinion, however. This is just a search to identify more relevant prior art. And the other option, which is described in Chapter 2 of the treaty, is a international preliminary examination performed by an international preliminary examining authority, or IPEA. And so since this examination is described in Chapter 2 of the treaty, it's often just referred to as Chapter 2 of the PCT. So if you ever hear that, you'll know what they're talking about. So how this works is if applicant wants to do Chapter 2, as we say, they would file a form that is called a demand. And it's essentially a request to continue prosecution of the international application during international phase. The demand is usually accompanied by either arguments or amendment to the description, claims, or drawings. So this is very similar to a response to a first office action in the U.S. and how applicant would respond. And there is, as I mentioned before, an extra, fee for this. In response to the demand, the IPEA issues an international preliminary report on patentability. This establishes a further opinion or report on patentability, taking into account any of the arguments and amendments that were presented by applicant. In rare circumstances, such as a disagreement with the written opinion of the ISA, the IPEA may first issue a revised written opinion before they establish the international preliminary report on patentability. So basically, it's like there's 2 rounds that happens, but not too often. Okay, so that brings us to the conclusion of international phase. So we'll just talk briefly about national phase of the PCT. So as illustrated on the timeline, the deadline for entering national phase in most countries and regions is 30 months from when the first application was filed. And by entry into national phase, we mean the start of patent prosecution before a national or regional patent office. And it's important to recognize that entry is not automatic. So an applicant must express their intent to seek patent protection in each nation or region of interest. Okay, so they need to reach out to the different offices and say, I want to pursue patent protection in your office. There are a few acts, such as the one I just mentioned, reaching out, and requirements to be met in order to be accepted by the national or regional office, but they're pretty simple. So those requirements are that the national or regional office needs a copy of the international application. However, if the international application has been published, then that requirement is met. So by publication, the International Bureau, as soon as the applications are published, provides them to any office that needs them. There may be the requirement for providing a translation of the international application, right? Just depends on what the country is and such. And there will be a national fee. So pretty easy to do. There could be some other requirements. They're not huge. The PCT applicant's guide that is produced by the International Bureau, and at this link here, provides the details for each office. A good example of an additional requirement is what the USPTO requires, and that is an inventor's oath. So why foreign file using the PCT? Well, it may be cost effective, especially if filing in more than a few countries. It provides additional time to identify the countries and regions in which an applicant wants to pursue patent protection. So while preserving their rights, that time is useful for assessing commercial potential in the various foreign markets and doing the other, homework. It defers the payment of fees that are required in each country. So there still is the national patent fees, fees for translations, for hiring legal counsel, and so forth. But it's just they're not due until at least 30 months, as opposed to the 12 months, with the direct filing. And another big bonus is it provides an assessment opportunity of the results of the search report and written opinion. So a first search has been done that sheds light on potential patentability and can help in making decisions as to whether or not, to pursue patent protection in other countries. So for more information about the PCT, here's 3 recommendations. There is the Manual of Patent Examining Procedure, referred to frequently by its abbreviation, the MPEP. The USPTO website has some PCT pages where there's information about forms, fees, rules, and so forth. And the WIPO website has a lot of good information about the PCT. I've mentioned already the PCT Applicants Guide. That's a great one. Patent Scope, which is the database of PCT applications. There's a PCT newsletter monthly, and so forth. And lastly, but not leastly, at the USPTO, we offer 2 services to help you get answers to your PCT questions. The PCT Help Desk Call Center can answer your questions during normal business hours. And these can be questions that are of general nature or about specific PCT applications, one that you filed. There's also a PCT email account. However, it's only for general questions and not application-specific ones. So now we want to move on to the Hague system, which is about international design applications. So under the Hague system, a single international design application is filed in order to obtain a single international registration for multiple countries. So up to 100 industrial designs can be included in the single application as long as all of the designs belong to the same Locarno class. When one files this international design application, one must designate 1 or more contracting parties where international registration is desired. The International Bureau is the one that registers the international application in the International Register. Once it is compliant with the formal requirements that are set forth in this in the Hague Agreement, the treaty. So substantive examination, if any, begins after the international registration is published. But if a designated contracting party does not timely issue a refusal of the registration, the default is that the registration will have the effect of a grant of protection in that contracting party. So here is a world map similar to the PCT one that illustrates in dark blue all of the countries that are, well, the contracting parties of the Hague Agreement, 82 contracting parties comprising 99 countries. So importantly, the Hague system is primarily a procedural system. So it does not determine the conditions for protection in any particular country or the rights which result from the international registration, the protection. So that is all governed by each, the laws of each contracting party. So the scope of protection is governed by the laws of each contracting party. So who can take advantage of the Hague system? Well, in order to file an application, applicants must have an attachment to a contracting party. And by attachment, we mean nationality, domicile or habitual residence, or a real and effective or commercial establishment in that contracting party. If there's more than one applicant, then each applicant must have a connection to a contracting party. A Hague application must be filed in either English, French, or Spanish. There are a single set of formal requirements. Remember, formal requirements, is stuff like paper and margins and sections and all that. They're set forth by the treaty. As mentioned before, up to 100 different designs can go into one application as long as they're part of the same Locarno class. The application can be filed directly with the International Bureau of WIPO, which saves time. However, the USPTO is an office of indirect filing, so it can be filed through the USPTO, as we'll mention. There is a single set of international fees payable to WIPO, and the fee amount is based on the contracting parties that applicant selects. So each country has its own rate, so to speak. In order to take advantage of indirect filing through the USPTO, applicant must have a US attachment, and the application must be in English. There is a transmittal fee of $130 currently that's paid to the USPTO. It is eligible for the discounts for micro and small entity. The international fees that WIPO requires can be paid through the USPTO in US dollars, or they can be paid directly to WIPO instead. But in that case, then they have to be paid in Swiss francs. So to take advantage of paying in US dollars to the USPTO, that payment must be made before or at the same time as the transmittal fee. So once the Hague application is filed, the IB evaluates it for compliance with the formal treaty requirements. If there are any issues, defects, then an applicant normally has 3 months to make the corrections. The IB then records the compliant international registration in the International Register. It translates the application into the 2 other languages so that you end up with English, French, and Spanish copies. And it publishes the international registration in the International Designs Bulletin. And that happens approximately 1 year after filing. And finally, it distributes the fees that were paid to the different contracting parties that were selected by applicant. So what do the contracting parties do? Well, in some cases, there is a substantive examination, but not always. They don't have to do any type of formalities examination because the IB has done that. As mentioned before, if they refuse the international registration, then there is a deadline of 6 or 12 months, depending on the country, for refusal. And if refusal doesn't happen, then protection is granted. So for the US, it's 12 months. So what is the scope of design protection? So as mentioned before that it varies per country, but in terms of duration, uniformly there is an initial period of protection for 5 years subject to renewal, and together there must be 15 years minimum of protection. So for the United States, protection begins on the day of issuance of a U.S. patent, although provisional rights may be available from the date of WIPO publication, and the duration is always 15 years. So
we just dropped you, we dropped your audio. Karen, can you speak up a little bit again?
I will get close and yell. I'm
Oh,
sorry.
sorry, we're not able to hear.
I will, yeah,
There we go.
bring this right up to my face here.
Gonna be a big microphone. There we go. We can hear you, Karen.
Okay, you probably hear me breathing. Sorry about that.
No, you're good.
Okay, so just one last slide about the Hague Agreement, just a listing of where you can learn more about the Hague system. The Manual of Patent Examining Procedure, NPEP, Chapter 2900, is devoted to the Hague system. The USPTO website has Hague pages where there are forms, fees, frequently asked questions, and so forth. The WIPO website has wonderful information about the Hague. They have guides, fees, there is e-Hague, tutorials, all this sort of stuff. Okay. So that kind of wraps us up with the two international treaties wanted to talk about. Know we're running behind because of all the audio problems. Just briefly mention some general helpful hints. Maintain confidentiality is a key recommendation that we make. Help you avoid disclosing your invention that may work against you. It's important to be familiar with key dates and deadlines. These dates and deadlines would be under US rules, foreign rules, the international laws. Don't want to miss a deadline. And we recommend securing the services of a registered patent attorney or agent, especially if you're unfamiliar with the complexities of obtaining foreign patent rights to avoid potentially losing patent rights. Little mistake can have big consequences. How to find a local legal counsel? Well, local industry contacts are a good place to start. Also the U.S. Embassy in each foreign country, inventor organizations, and then within the U.S., the USPTO practitioner homepage lists all of the registered attorneys. Some general resources. So you, if you've been coming to this presentation, this series, you're familiar with USPTO.gov and the resources, some of the resources at least that have been listed here. Great inventor resources. There's Patent Center for the electronic filing, application, inspection, and management. There is a search tool for patent publications, a current schedule of fees. Always important to look at this repeatedly because fees do change multiple times a year sometimes. And as mentioned before, PCT and Hague filing information. So these first three bullets here are touched on the next few slides. As far as inventors resources goes, there is the Inventors Assistance Center. There are a load of inventor and entrepreneur resources. This site is a hub for information for inventors, entrepreneurs, and small businesses. And third, the USPTO Pro Se Assistance Program provides outreach and education to applicants who file patent applications without the assistance of a registered patent attorney. The USPTO Patent Pro Bono Program is a nationwide program that matches financially under-resourced inventors and small businesses with volunteer patent practitioners to file and prosecute patent applications. And then one last resource to mention is the stakeholder training on examination practice and procedure called STEP. It's training for the public that's based on courses available to USPTO employees. So the aim is to better provide an understanding of how examiners make their decisions. So Patent Center, that is the subject of part 7 of the Path to a Patent series, which is next in this series, I believe. So this slide deck only has a high-level overview, just mentioning here that it has a training mode option, so that you can become more familiar with using it before you file. This is the Patent Center homepage. It has a search function for searching for patent applications, and you can perform a number of other activities such as new submissions, post-grant requests, administrative tasks, and so forth. But to do everything you need to have, make full use of it, I should say, you need to have a USPTO.gov account. For this search function here, you can just enter an application number that you want more information about, and you did that for just a random application, and this is the search result. And showing this because if you select the Documents and Transactions tab, what you'll see for that particular application is all of the public data, the prosecution documents. They can be viewed and downloaded. So patent public search is also part of the, there's a devoted lecture on this, part 3 of the Path to a Patent series. So it enables full text searching of U.S. patents and published applications using either simple or complex queries. Similar to how examiners search. And here is just a listing of some other intellectual property resources useful to someone pursuing foreign.
Can you speak up again, Karen? Sorry.
So just a listing right here I've mentioned before.
I think you need to adjust again, Karen, the speaker. I don't know if it's the mic or the speaker that you have there.
I am holding it up.
There we
close to
go.
my face.
There we go. We can hear you now.
Maybe there's something electrical here. I don't know. I'm holding it near my face, so like 6 inches.
We can hear
But
you.
we're almost done.
Mm-hmm.
So there are some other databases for patents that you might find useful, like the European Patent Database, eSpaceNet, as well as JPlotPat, which has, in addition to Japanese patents, also Japanese utility models, designs, trademarks, and some other foreign publications. So these are just 2 examples. There are, of course, more. And this is just a reference slide for your convenience of various abbreviations that are used in this presentation and you might come across regarding foreign filings. So this concludes today's presentation.